Hello everyone, welcome to BYJU'S Exam Prep. I'm Nivedita Raje and this is the first session of a legal analysis that we are going to conduct of the editorials. So these editorials, like I told you before, would be taken from various sources such as the Hindu, Indian Express, the Frontline. These are the major sources where the consortium also takes its editorials from. So what we are going to do in this session is we are going to take one editorial which I suppose is quite relevant in accordance to your all the law entrance, and then I would explain to you the significance of it, the concept that is given in the editorial and all the related concepts, right? So it's going to be a comprehensive analysis of Hindu editorial, something which you really need, because as soon as an editorial starts to have a legal sorry tone towards it, it immediately becomes complicated. There are so many concepts and laws and acts that you are not really familiar with, right? So we are going to do all of that. Hello, good afternoon all. How are you? How are you? Good afternoon, guys. What is happening? How is everyone? I hope everyone is fine. Now the scorching heat has come to an end. We are endowed with the blessings from Indradev. The temperature is not as high, so it's not like you are melting. Everything is cool and nice. That's my side of the story. So what is happening with you? Apart from the fact that I'm pretty unwell, you can sense that sickness in my voice, I think. But apart from that, I'm okay. So tell me something interesting. What is happening? After which we'll discuss why we are conducting this session or why we have decided to conduct the session. Okay. So now the thing is that, editorials or sorry. So editorials basically, especially the Hindu editorials, they're not as easy. And I've heard this a lot of times that uh, students find it complicated. There are problems associated with the language. And whenever you read the editorials, it's always as if, what am I reading? What is it? What is PMLA? What is ED? What is everything? Welcome, Shraddha. I hope you enjoy the session. Try to be with us. You'll enjoy it. Okay. Yes. So basically what happens is that, these editorials are complicated in themselves. The language is pretty tough. The literature is not as easy. The vocabulary, I don't know where it is taken from. And if a legal editor if an editorial becomes legal in nature, like they're discussing a particular law or a policy or anything that a parliament is doing or the Supreme Court is saying, it becomes even more difficult. Like, you don't know the background of it, you don't know what Supreme Court is saying, because you don't know what the trial court said. Obviously the Supreme Court is the last court in the chain, so a lot of things have already happened to that case law before Supreme Court started saying things and newspapers started publishing it. So that background becomes complicated. The cases are so lengthy, right? And the agenda, the objectives, everything. So what I'm going to do is I'm going to make them simple for you, right? Simple in a way that you can understand, while you can connect it to your exam. And whenever you read any editorial on your own, you would understand how to go about it. Okay, so let's start. Today's article of discussion is PMLA and the Supreme Court verdict on PMLA. Now, what exactly is PMLA? PMLA is Prevention of Money Laundering Act. Right? Prevention of Money Laundering Act. Now, basically, the background of the case is that there are several provisions from Prevention of Money Laundering Act that were challenged, right? And this editorial is basically talking about the verdict of the Supreme Court and what the Supreme Court has said in regard to all the provisions that were challenged. So the entire act wasn't challenged, but there were certain provisions that were challenged. So Supreme Court has taken a stance on every provision individually, and that is what this editorial is telling us, right? And that is what we are going to discuss. Now, we are obviously not going to discuss everything. We are going to discuss the major things that I think are important for you. Everything is never important. Even a Supreme Court judgment in its entirety is not important. That is why these sessions that we conduct on YouTube and on our app with regard to current affairs, you should always watch them, because that would give you an idea that your syllabus is not that much actually. It is only a handful that you have to study and you are done. Right, so prepare strategically, and that's how you prepare strategically. You stick to the most important things, and in while doing it, you actually channelize your energy to something which is more or which is better. Okay, so let us start. Now, like I told you, today's editorial relates to a Supreme Court verdict on PMLA, or Prevention of Money Laundering Act. Let's first understand the meaning of the following. ED, or Enforcement Directorate. We are going to study the meaning of this. What exactly is PMLA and what exactly is money laundering? Now, before we discuss first what ED is, let's discuss what money laundering is. Let's understand it through an example. Let's say that there is a person who is making a lot of money. Okay, he might be a minister, he might be a businessman, and whenever you make money, whatever source you're making money from, unless and until you show it before the government, that money remains illegitimate. Okay, so let's say that you are doing something illegal. Now we are talking about money laundering per se. Let's say that you are doing something illegal. Whenever an illegal task is done, the payment is always done in cash. Have you ever seen a police official or a public official taking bribes in check and GPay? Matlab, can you imagine a police officer telling you, there's a little bit of fee that I charge, you can Google Pay it to me or you can Paytm it to me? Obviously not. He'll take it in cash, so that there is no proof. Okay, if the transactions are conducted in cash, there is no proof, there is no accounting, nothing whatsoever. So whenever a money or an amount is acquired from an illegitimate source, it is always acquired in cash. Now, this cash is too much, but the people earning this kind of cash, which is also known as black money. Why is it known as black money? Because people cannot spend it. Now, let's say that you have an unreported 20 lakh of cash with yourself. As soon as you start spending it, there would be an immediate, I'll take session on all the important articles. Harium, don't worry. I would request you to focus right now on this session. Okay? That is more important, buddy. Trust me. Now, a person who is making money from an illegitimate or an illegal source cannot spend that money. Why? Because there is no proof of how that money is earned. That money is not accounted for. Government doesn't know about that earning, so it is obviously not a legal earning. It is in cash. If you start spending it, there would be questions as to how do you have this much money? Who is paying you 20 lakh in cash? And then there would be questions. Income tax would be involved, ED would be involved, and your money will be taken away from you. And that is why people choose to hide that money and do not spend that money. And this kind of money is called black money. A money or an amount which is hidden. From who? From the government. Okay, clear? Now, obviously, if you have so much cash and you cannot even spend it, what is the use of the cash? Right? If I have a room full of cash and I cannot spend it, it's just, paper occupying my room. It's of no use until and unless I start spending it. But I cannot spend it for the reasons I just told you. So there are agencies actually. They take all of your black cash and they convert it into white. There is an entire channel. They take the entire money, they deposit the small sums into different banks, or they give it to big people or important rich people who then deposit them into their bank accounts. Banks are involved, rich businessmen are involved, where many people are involved. That money is channelized through legal sources. For example, I gave about 20 lakh to a person to convert it into white. Now he will charge a certain fee for himself. He'll take his cut, and rest of the money he will convert it into white. How? He'll give it to various sources. He'll deposit it in different bank accounts registered with under different people names. Those people will donate that particular sum to certain NGOs, and in the garb of collecting the money from NGO, that I have an NGO running and I get donations in that NGO. That black money gets converted into white money, and this entire process is called money laundering. Did you get it? Now all the money that comes from black to white, it is always coming through the sources which are tax free. For example, NGOs, charitable hospitals, charitable education institutes, the babas, the religious people or the god people, who whatever they get is absolutely tax free. Temples, religious institution, whatever they earn, whatever donation they get, everything is tax free. So all of that is collected in the name of donation, which is tax free, and the person gets it. He gets all the black converted into white, and he doesn't have to pay tax. So the government is actually a government gets there's a lot of controversy involved around this process. Why is money laundering so bad? Why shouldn't we allow it? How is it crippling our economy? The problem with this is, guys, the commission or the cut that these people take, no, that the middle agents, that I will convert your black into white, but I'll take my fee, obviously. So they take 10% on whatever the amount is, and the amount is generally not in lakhs, it is always in crores. Okay. So whatever the cut that they take is generally used to do more illegal things. And it has been found by research that this cut is mostly used to fund the non-state actors, which means the terrorists organizations. So the cut and these people are always coming from criminal background, and this cut is used to fund more criminal activities such as trafficking, terrorism, etc. Got it? This is the process of money laundering. Now, who is in charge to stop this money laundering? ED. Enforcement Directorate is the authority that is created to stop the process of money laundering. And how do they do it? They do it using the act created for them that gives them an immense power to control and to stop this activity, and the name of the act is PMLA, Prevention of Money Laundering. Did you all get it? Is there any doubt whatsoever? Did everybody get the concept? I'm hoping you did. Okay, so let's study a little bit about ED. Whatever concept, whatever constitutional or non-constitutional body that you see in a judgment or in a whatever legal editorial is there, immediately know its background, because it becomes important. Since this judgment deals with ED and PMLA, ED and PMLA both become important. Okay, you should know the background. When was it established? Who is the director of ED and everything? Okay. Now, it was established as it is written here in May 1956 with the formation of an enforcement unit under the aegis of Department of Economic Affairs, and handles exchange control laws violations under FERA, Foreign Exchange Regulation Act. Okay, the headquarter of ED is in New Delhi. The director of ED right now is Sanjay Kumar Mishra, IRS. Okay, now we know the background of the story, what happened in this case. Okay, ED is empowered to stop and prevent the process of money laundering, and the legislation that gives ED the power to do so is Pmla. Now, the basic highlight of the article is that there were several provisions in Pmla which were challenged on grounds that they violate the Constitution of India. Okay, there was a whole lot of debate on it, that you convert or you investigate in this manner, this is what you do, this is what you do. The provision giving you the power to do so is absolutely violative of the Constitution of India. It is absolutely different. It should not happen. Right. Now, the Supreme Court came out with the judgment and said that none of the impugned provisions or the challenged provisions are violative. And the Supreme Court has upheld all the provisions. So, according to Supreme Court and what the article is telling you, every provision that was challenged on grounds of constitutional validity is upheld. Okay, Supreme Court has held them to be completely fine and they are not violating Constitution in any manner whatsoever. This is what the editorial is all about. Okay, now we shall discuss the challenge provisions and we shall also understand the related concept for our CLAT. Okay, moving on. Now the first issue that was challenged, or the provision that was challenged by the process of investigation. Now let's understand it this way. Whenever a crime is committed, the report that gives the information of that crime or that sets the entire criminal machinery into motion, that tells the official that the crime has been committed, become active immediately, figure out who committed the crime, stop the public peace from disrupting. So all of this is reported in an FIR, First Information Report. Okay. Now, there is a certain process of FIR, meaning thereby that FIR is a public document, which means that whenever a person is reporting a crime, his crime is written down in the FIR in exactly the same narrative as the person was providing. Okay, the person keeps saying, the police officer keeps writing down the narrative. After the narrative becomes over, the report is entered into a police diary and the copy of that report is given to the person who lodged the FIR. Got it? Now the same copy of FIR is included in the investigation report. Okay, and whenever a person is arrested, the information that is given to him regarding his arrest makes it mandatory that FIR should also be given to him. So whenever a person is reported or is informed that you have been charged with this crime, they are given the copy of FIR. That a buddy, an FIR is registered under your name. This is all what the FIR says. You are now required before the court. It is not a warrant, but it gives a person, it alerts the person that, oh my god, a case has been registered against me, now I need to see a lawyer and everything is arranged. Okay, so if a person is summoned to the court or if a person is arrested, the copy of FIR is always given, so the person knows what is exactly he's charged with. That is the entire paradigm of criminal jurisprudence or criminal machinery, that you need to inform the defendant what is he charged with. If you are charging him with murder or theft or robbery, whatever it is, tell him that, buddy, you are being accused of murder, rape and robbery. You need to tell him that, so that if he can prepare a proper defense. Okay, this is the process of FIR. Now, the problem in Pmla is that the case regarding money laundering is registered as Enforcement Case Information Report, ECIR, and it is assumed to be equivalent to an FIR in ordinary cases. But since cases relating to ED are not ordinary cases, obviously the entire process will also not be ordinary. Now, whenever a summon is issued to a person, whenever there is a charge of, whenever ED starts investigation and summons are issued to a person to provide with a defense and to show cause in front of the court and to appear in front of the court, he is unaware of everything. ECIR is not provided to him. Why is he charged? Why is ED even targeting him? What has he done? No information is given to him. So he has to answer all the questions without knowing the questions. He has to attend all the proceedings without knowing anything about them. And he has to submit all the documents that he's asked for without even knowing that I might be asked for something like this. So whatever happens, whichever manner the investigation proceeds, the defendant or the person targeted is completely unaware. He doesn't know anything, what documents he is to furnish, what defense he has to create, nothing whatsoever. He is absolutely unaware of the reason, of the cause, of anything of why he is being targeted by ED or why an ECIR has been registered against him. But since it is a white collar case, it's a big case, he has to cooperate with all the proceedings, otherwise these people will arrest him. Did you get it? Everyone? Is it clear? Am I confusing you? Anything? You can tell me right now. Clear? Clear? Okay, I'm assuming that we are clear. Okay. Yes. Now, the above investigation, like I told you, cruel. It's not cruel. The above investigation is pretty different than the usual process. Now, what is the usual process? The usual process is given under section 50 of the Criminal Procedure Code, which gives a person a right to be informed. So, section 50 of the Criminal Procedure Code, read with article 22 of the Indian Constitution, says that a person who is being arrested or who is being taken into custody for anything whatsoever needs to know why is he arrested. Okay, the reasons for his arrest need to be furnished to him. That is a fundamental right as according to Article 22. Right? Since it is a fundamental right, if any official chooses not to follow this step, the detention becomes what? Illegal immediately. The detention becomes illegal if a person is arrested without telling him the grounds of his arrest. As soon as the arrest becomes illegal, it can be challenged under Article 32 or 226 using the writ of habeas corpus. Got it? So as soon as a detention becomes illegal, it can be challenged using habeas corpus, which means produce the body. ED is Enforcement Directorate. Okay, which means produce the body. So whenever a person feels that the detention or the way he is detained is illegal, the procedure established by law is not followed, he can invoke his constitutional writ in front of the High Court under Article 226 or Supreme Court under Article 32, challenge the detention. The detention can be challenged even if it is done by a private individual. So state necessarily need not be involved. Even if a private person, father, mother, brother, conservative family has detained a daughter or a son, somebody on their behalf also can file a writ. This is the only writ which provides such extended remedy. Okay, with the relaxation of the rule of locus standi. Now, the court will look into the detention, see if it is unconstitutional, see if it is illegal, and immediately ask the person to be released, whether he is contained by his own family members or a public official. Okay, now habeas corpus is your homework. I would request you to read habeas corpus, very, very important. In fact, it was asked this time in the exam. Okay, yep. Moving on. Now, the court rejected these contentions and the conclusions were that ACIR and FIR are completely different. Okay. You have, when it comes to that much amount of money, people get a little bit of, paranoid. They would do anything in their power to hide that money. They would do anything in their power to save that money from the clutches of government, right? Because that money makes man very, very selfish and very, very greedy. So they can do anything so that government does not touch that money. And if we are to do something significant, if we are really to catch a person who is earning illegally, not reporting his income to the government, we need to have sufficient safeguards in the entire process of survey and search. We cannot alert them telling them, oh my god, we are going to do this, now we are going to do that, you be alerted, hide the money. We cannot allow that much leeway to anybody who is being targeted by ED, because they have not just committed a crime, they have actually, hidden a lot of money, which is uh, which is creating a crumble in the society, in the economy. The society is crippled because of people doing these kinds of activities. They cannot be given any chance to run or hide or anything. That is why the process of investigation conducted by ED is completely valid as per the requirements. Okay, did you get it? Despite the fact that we need to have a safeguard in the entire process of survey, search, seizure, and arrest, the law officer is still responsible and he is under a duty to write down all the reasons of what he's doing. If he's arresting the person, he needs to write down the reasons. Even if he is not showing the reasons to the person arrested as such, but the reasons would be furnished to the court conducting trial of the entire investigation. So at every stage, the officer responsible for the record and for the investigation needs to furnish reasons. I am arresting this person, this is the reason. I am conducting the search, this is the reason. I am seizing the assets, this is the reason. I cannot give him bail, this is the reasons on every step or every stage that he is conducting. Okay, at the time, if a person is actually getting arrested, if he is getting arrested, the police officer has to furnish reasons, not only in written, he also has to tell the person why he is arrested, even if the provision for that is not given in Pmla. Okay, so that's how the Supreme Court has saved this provision. Everybody clear? Any doubt whatsoever? Tell me, hurry up. Any doubt whatsoever? Nobody, any doubt? Good. So class is pretty dull. What is happening? No doubt. Be proactive. I'm teaching you despite the fact that I cannot really speak. You are not even able to text or tell me that it is clear. Okay, it gives faculty a certain amount of confidence. Now, the burden of proof, the actual position of burden of proof is actori incumbit onus probendi. So let's say that A filed a complaint or FIR against B, that B has stolen A's necklace. Okay, so A has accused B of what? Theft. Got it? Now in this process or in this scenario, if the case reaches the court, okay, the case reaches the court, in the trial, A will be called the plaintiff while B would be called a defendant, or A would be called the prosecution and B would be called defense. Okay. Now, the prosecution has charged or accused the defense that he has stolen some items from A. Now, since A is putting the allegations, since A is accusing B of theft, it is A's responsibility to prove that B has stolen the items. This is what the meaning of this particular maxim is. Actori incumbit, onus probendi, which means that whoever alleges, whoever says that I am saying this or I am alleging this, or whoever put forth any fact in a manner of allegation, evidence, testimony, he has to prove that fact. So the burden of proof is always on the prosecution. Why? Because he is the one making the allegations. So if you are alleging something, you need to prove the allegations. This is how the burden of proof goes on in an ordinary trial. The burden of proof is always on the prosecution, with few exceptions of section 304B and 113B of Indian Evidence Act. Okay. So the burden of proof is always on the prosecution because he is actually contending or saying or stating the existence of certain allegations. These are the certain things that have happened. Now I need to prove them also. Okay, the burden of proof. The Latin maxim that is supporting this stance is actori incumbit, onus probendi. The burden of proof is upon the prosecution. Got it? Now, the thing is that the position of Pmla is very, very different. How? Here, the burden of proof is not really on the prosecution, which is the ED in the case. Okay, ED is the prosecution. The burden of proof is on the defendant. He needs to prove that the charges against him are false and contrary. Sorry, they are false. He has not hidden any money. He is not earning anything illegally. He has no amount of black money that he is being alleged to have. So the burden of proof is not on the ED to prove this money is hiding that much income. No. ED has said that we believe the man is hiding this much income, unreported, black, etc., etc. Now it is on the defendant or the person charged or alleged with this fact to prove that I did not hide anything, I do not have anything. He has to prove his innocence. In the usual case, nobody has to prove any innocence. No defendant has to prove that he did not commit the crime. The only job that he has is to rebut the evidences that are given against him. So if A is presenting an evidence to support that B stole the items, the only job of B is to rebut and prove this evidence to be false. That's it. That's it. But in the proceedings of Pmla, B is entitled from stage 1 till stage end to prove that he is completely innocent and the charges against him are false, which is absolutely contrary to the usual position. Now, this was challenged as being violative of Article 14. Sorry. Guys, can you give me a second? Okay. Sorry. Yes. Yeah. Now, this actually is held to be violative of the usual position of Constitution. How Article 14 is involved in a manner that Article 14 says what will happen if he is innocent? He will be released. Very simple. You cannot punish an innocent man, but he has to prove his innocence. Very simple. Okay, so Article 14 was it was challenged on grounds of Article 14, very simply saying that it is violative of Article 14 because if a person is charged with any other offense, you give him the benefit of doubt that he might be innocent and you leave the burden to the prosecution. Prove your allegations. But when it comes to money charges or money laundering charges, your criminal jurisprudence takes a complete different stance altogether. You give him different proceedings, you see him differently, and now you are burdening him uh, with the charge of proving himself innocent, which is actually pretty contrary to what your criminal jurisprudence says. The criminal jurisprudence is based on the philosophy that person is innocent until proven guilty beyond reasonable doubt. Every person is deemed innocent in our criminal jurisprudence until the prosecution establishes his guilt, and that guilt established without any doubt whatsoever. Everybody in the court, the judge, the procedure, the stenos, everybody who's present in the court should be able to believe completely 100% that there is no doubt the person is not a criminal. Until and unless the charges are proved in this manner, that person will not be punished. Got it? That person will not be punished. Now, competition. What do you mean competition? Compensation. No compensation. No compensation. Right. It doesn't happen in India, sadly. Because ED is a government agency, no? Now, since people who are charged under Pmla do not get treated the same way as ordinary culprits, it was said the article or the proceedings are completely violative of Article 14 in a manner that you are treating people differently. Okay, you're treating people differently. Article 14 does not allow it. It says everybody is to be treated equally in the eyes of law. Now, Article 14 does not just say equality or does not just provide for equality. It provides for equality among equals. Right? And there is a test which Article 14 lays down. Test of reasonable classification based on intelligible differentia, which means that if you are classifying people into certain categories, make sure that the classification is reasonable. You are classifying them on the parameters which are reasonable. Okay, so if you are classifying men from women, the parameter is reasonable. Obviously, men and women are different. Their basic biology is different. You cannot treat them equally. If you are categorizing an abled person from a disabled person, this categorization is reasonable. Why? Because obviously a disabled person is different from a fully bodied person. Got it? So if you are classifying or categorizing people, make sure that the parameter that you are doing it on is reasonable. Plus the reason why you are classifying, the object that you seek to achieve, because from that classification should be intelligent. Okay, so if you are classifying men and women, what is the object that you are doing it for? The object is to seek women empowerment. The object is to create an equal society where men and women can be equal. If you are categorizing or if you are giving reservation, if you are treating disabled people differently, why are you doing it? Why? What is the objective? What is the intelligible differentia? It is that the disabled people can also have a life of dignity. They are not dependent on their family members. They do not lead a life which is demeaning and low and is filled with low self-esteem. They can make their own life. They can earn their own money. They can do something for themselves, which would instill in them a sense of confidence. It would give them a new structure, a new life. It would make them independent. Right, that is the object. So Article 14 says that equality should always be conducted between equals. If a person is not equal to the other person, he cannot be treated like that. You cannot be equated with a child of the person who is working for you. Let's say you have a household help who comes every day to clean your house. She has a son. You cannot treat her son as you. He comes from a different background altogether. You two children are not equal, and hence you will not be treated equally. So the Supreme Court in this position said that the people who are charged with money laundering are different from people who are charged with ordinary criminal activities. If a crime is done, the maximum that you can do is hide the evidence. The evidence would be, would come out eventually. The person can be arrested. There are so many things that the investigating agencies can do in order to catch the criminal. But a person who is charged under PMLA is a wealthy, rich person who has too much money. If we give him too much time, he may bribe the officials, he may elope, he may hide the money and we'll never find it. He may convert the black to white and we will not be able to do anything. Because he is rich, he is powerful, he has enough resources in his hands. Right? He has different kinds of players, state actors, non-state actors supporting him. So it is difficult to arrest these kind of people because they form a different category of criminals. Plus the crime that they are committing is crippling the entire economy. It is laying the country weak, and that is why you cannot treat them as that of an ordinary criminal. And that is why the proceeding and the trial and the investigation process subjected to them has to be different from an ordinary criminal. So Article 14 is not violated. The burden of proof would remain on the person who is charged under PMLA. Got it? Is everyone clear? Any doubt whatsoever? I hope not. So that is it for today, guys. I hope you understood the editorial. You understood how important the editorial is, the background, the story, what the Supreme Court said. So this editorial analysis, legal analysis would be conducted every Saturday on the same time. Do attend these sessions. Editorials have formed an important part of your exam syllabus, as you already know. There are certain factors, certain terms that you get absolutely confused about, and if you face them in that exam pressure, you panic, right? So let's not do that. Let's attend these sessions that Nivedita ma'am is so generous to take, and understand the law properly through editorials and Hindu, which everybody says is so important, right? So guys, every Saturday at 3 p.m. What is the proceeds of crime? Proceeds of crime is basically what is recovered from the crime. Okay. Yep. So I shall see you next Saturday, like for this session. Otherwise, I'll see you almost every day. Till then, everybody take care. Bye-bye. Thank you so much and stay safe. Right? Bye-bye. Share the session, like the session. Nobody leaves without liking, and subscribe to our channel if you haven't already. Take care, guys. Thank you so much. Thank you so much, Ahana.